My friend sold his $2 million house without a real estate agent. Here's the legal strategy he used. A friend of mine recently went through a real estate transaction that I had genuinely never heard of before. He owned a house worth approximately $2 million. He needed to sell it, but instead of listing it with a real estate agent, paying a 6% commission, triggering a property tax reassessment, and going through the standard process, he did something completely different. He sold his LLC. The house was owned by a limited liability company, not by him personally. And instead of selling the property, he sold the membership interest in the LLC, meaning the company itself changed hands with the house still inside it. No listing, no commission, no deed transfer, no property tax reassessment trigger. When he explained this to me, I thought it sounded too good to be true. So I spent time researching how this actually works, what the real advantages are, and what the risks and limitations are. Today, I want to walk you through all of it, because this is one of those strategies that almost nobody explains clearly. Welcome to Fuel Your Wealth. Let's get into it. First, let me explain the basic structure. When a property is held inside an LLC, the LLC is the legal owner of the property, not the individual. A house, a rental property, or a commercial building can all be titled to an LLC. The individual is the owner of the LLC, not technically the direct owner of the real estate. When you sell property the traditional way, you transfer the deed, and that triggers a series of costs and tax events. A real estate agent commission typically runs 5 to 6% of the sale price. In California, the county charges transfer taxes at the time of a deed transfer. And critically, a change of ownership triggers a property tax reassessment, which can dramatically increase the annual property taxes. In California specifically, Proposition 13 caps property tax increases at 2% per year, as long as ownership doesn't change. But the moment a property is sold and a deed is transferred, it is reassessed at current market value. On a $2 million property, that reassessment can more than triple the annual property tax bill overnight. Now here is where the entity sales strategy becomes interesting. When you sell the LLC instead of the property, no deed changes hands. The same LLC that owned the property before the transaction still owns it after. From the county's perspective, the property has not changed hands. The entity that owns it did. This can potentially allow the buyer to step into the same property tax base the seller had, protecting both parties from an immediate reassessment. I want to be very clear about an important exception here. California law has a change in control rule. If a buyer acquires more than 50% of an LLC's membership interest, California can still treat it as a change of ownership and trigger reassessment. So the property tax benefit is real, but it requires careful structuring. This is not something you do without a qualified real estate attorney and a CPA involved. Let me walk through the other advantages. No real estate agent commission. A traditional 6% commission on a $2 million sale is $120,000. When you sell an LLC interest, you are technically selling a business, not real estate. No state law requires a licensed real estate agent to be involved. The transaction is negotiated directly between buyer and seller or through a business broker or attorney. That alone can save tens of thousands of dollars. No deed transfer taxes. California counties charge transfer taxes when a deed changes hands, typically based on the sale price. Because no deed transfer occurs in an entity sale, these fees are often avoided. Liability transfer. When a buyer purchases the LLC, they also step into any existing contracts, leases, or obligations the LLC holds. This can be an advantage. For example, existing favorable lease terms with tenants transfer with the entity. It can also be a risk, which is why buyers need to conduct thorough due diligence on the entity before purchasing it. The capital gains picture is nuanced. The seller still pays capital gains tax on the appreciation of the LLC interest. There is no magic way to eliminate capital gains entirely with this structure. However, the way gains are calculated and taxed can differ depending on how the LLC is structured, what depreciation has been claimed, and several other factors. This is highly individual and requires a CPA to model specifically for each situation. Now let me give you the buyer's perspective, because this strategy only works if a buyer agrees to it. And buyers have legitimate reasons to be cautious. When a buyer purchases an LLC rather than property directly, they do not get a stepped-up tax basis, meaning the depreciation history of the property stays with the entity and continues as is rather than resetting to the new purchase price. For a buyer who plans to depreciate the property significantly, this is a real disadvantage. This is one reason why sellers who want to do an entity sale sometimes have to price it attractively to compensate the buyer for taking on this structure. Lenders also have opinions here. Mortgages financing a property inside an LLC have different terms than mortgages on personally owned property. Buyers who need financing need to work with lenders who specialize in commercial or investment property lending through entities. Here's the bottom line. The entity sales strategy is a legitimate and powerful tool, particularly for sellers of high-value investment properties who structured their ownership through an LLC from the beginning. For the right situation, it can save significant money on commissions, transfer taxes, and potentially property tax reassessment. But it is not a universal solution. It requires the property to already be in an LLC. It requires a buyer willing to purchase an entity. It requires careful legal and tax structuring to realize the full benefits. And it is absolutely something that should be done with a real estate attorney and a CPA experienced in entity transactions, not attempted without professional guidance. If you own investment property and you are not holding it in an LLC, this is worth a conversation with your attorney about whether restructuring makes sense for your situation going forward. Don't forget to like this video and subscribe to Fuel Your Wealth for more videos like this every week. This is not financial, tax, or legal advice. Always consult qualified professionals before making any decisions about your real estate or business structure.